Good morning, everybody. Thank you for attending today's presentation. Just a couple reminders before we go ahead and get started. Please leave your microphones and cameras off during today's presentation. Also, if you need a certificate of participation, can you hear me?
I can hear you, Kylie.
I got muted there for a second. Okay, so please leave your cameras and microphones off during today's presentation. Second, if you need a certificate of participation, please email Marilyn at the end of today's presentation and she will get that out to you. And lastly, but most importantly, please fill out the survey at the end of today's session. It literally takes maybe a minute or two to fill out. We appreciate any and all feedback regarding presentations, future presentations, and just anything to make these trainings continue to be successful. So we gladly appreciate those surveys being filled out. So with that, I will turn it over to Christina, and she is presenting on evictions today.
Thank you, Kylie. Very much appreciate it. This has been the 2-3 years, I think I've given this presentation for this particular group. So it's always a pleasure. Just want to tell you a little bit about myself. I am the partner here at Makoff Kellogg Law Firm in Dickinson, North Dakota. And I have been practicing for approximately 10 years, come this year, actually. A lot of what we do in my practice particularly is working with landlord tenant law. We represent landlords in our office. We don't represent tenants. And we handle evictions all across the western side of the state. Even up Williston, Watford City, a lot of them in Dickinson and some of the smaller surrounding communities. So got a wide variety of knowledge with regard to evictions. So I'm hoping that this presentation is going to be helpful for all of you. And then of course, I'll take questions at the very end as far as any questions are concerned. So let's hop right into it and we'll get started. So the first basic primary question is, what is an eviction? And the eviction statute in North Dakota is very succinct. It's very simple in the fact that it's not a lot of pages. It's very brief. But essentially what the eviction statute allows for is the legal process to recover the possession of real estate under certain circumstances. And one of those, a couple of those circumstances are as follows, and I'll walk through them. A party by force, intimidation, fraud, or stealth has entered upon the prior actual possession of real property of another and detains the same. For example, someone, forcefully walks into someone's home and doesn't leave and threatens them for whatever reason. That would obviously constitute an evictionable action. Number two, a party after peaceably entering upon real property turns out by force, threats, or menacing conduct the party in possession. For example, you have a tenant that is lawfully in the residence and eventually, for whatever reason, is threatening someone or acts in a forceful or threatening manner. That could also result in eviction. Number three, a party by force or by menaces and threats of violence unlawfully holds and keeps the possession of any real property, whether the possession was acquired peacefully or otherwise. Kind of goes back to subsections 1 and 2. A lessee in person or by subtenant holds over after the termination of a lease or expiration of the leasee's term or fails to pay rent for 3 days after the rent is due. This one is the big one as it relates to this particular presentation where we've got a lease that has expired and the tenant is still in the unit, or we have a situation where the tenant is failing to pay rent and then we have to evict for failure to pay rent. A couple other examples of when an eviction is maintainable. Number 5, a party continues in possession after the sale of real property under mortgage execution order or other any judicial process. This basically would mean as if a house was foreclosed on and that a former mortgage or was still living in the premises, then the bank generally would have the ability to evict them after a foreclosure action is concluded. Number 6, a party continues wrongfully in possession after a judgment in partition or after a sale of order or decree of the district court. Again, that would be a situation where a individual had a partition action through the court and they were required to vacate particular sections of that property. They didn't do so. Court could authorize an eviction action. Number 7, a lessee or person on the premises with the lessee's consent acts in a manner that unreasonably disturbs other tenants' peaceful enjoyment of the premises. This is the second big one as it relates to this presentation. For example, if you have tenants in the property that are having loud parties, disturbing the peace, cops are being called, those types of situations would result in an action being maintainable under subsection 7. And then finally, number 8, the lessee violates a material term of the written lease agreement between the lessor and the lessee. For example, if the material term of a lease is that the tenant should not be smoking in the premises, that would be a violation. If the lease provides that the tenant is to maintain the tenant is to maintain the common areas or pay fees or something of that nature, that would be a material term that's not being complied with, which could result in the action being maintainable for eviction. So let's talk specifically with regard to the failure to pay rent. This is the most common reason for eviction, at least in my practice. And essentially what happens is common sense would tell you that you have a tenant that's just not paying rent. And the statute requires that rent, in order to be able to proceed, the tenant has to fail to pay rent for 3 days after the date rent is due. Now, really important that you check your lease and make sure that you're aware of the penalties for failure to pay rent timely. Does the lease provide for late fees? If they are provided for, what is the cost of those late fees? You should check your lease because these terms can vary by statute. And does your lease require a longer notice period before eviction can be commenced? So, if your lease says that you are required to give someone 30 days notice upon failure to pay rent of an eviction, then you have to give them 30 days notice as opposed to the 3. So it's really important to make sure that you've read, as a landlord, that you've read your lease and you make sure that understand what it means before you are serving any notices for failure to pay rent. Sometimes I've had judges in our district, even though the lease provides for late fees, they have refused to enforce them. One judge in particular in our area has done that in the past. Most of the judges that I have dealt with generally award those as part of the written lease agreement. Disturbing the peace. This is, again, as I alluded to, this is something where you've got loud parties that are occurring. Maybe you have the cops being called on a consistent basis. It's very important to make sure that your lease includes this provision. It's one of those things that we kind of would seem to be, it would be self-evident, but it's very important that you have it included in the lease because not only would it be a violation under the statute, but it could also very well be a violation of the written lease agreement and be a material term that would result in an eviction action. Some of the examples, again, loud parties, loud music, fighting. If you've got a constant situation where you've got, roommates consistently getting into arguments with one another, erratic behavior. We've seen some of this a little bit with mental health issues with some tenants. So any one of those can and could be a reason for maintaining an eviction action under the disturbing the peace statute. Next one, again, the third biggie when it comes to the maintaining the eviction would be the material breach of lease. This is when a lessee violates material term of the written lease agreement between the lessor and the lessee. This is in a lease, in my opinion, it's kind of a catch-all provision. So you could for certain have examples like no smoking, no pets, that you're required to keep the property in a cleanly fashion. You're required to have upkeep of the property, and you're required to not engage in any illegal activity on the property. Any one of these could result in a material breach of the lease, which could result in an eviction action. So first of all, we've talked about what constitutes an eviction or how you can get an eviction. Let's talk about what the process is for that eviction. So first and foremost, under North Dakota law, you are required to give a notice to quit to the tenant. There's a couple different terms that we technically use. It could be a notice to quit. It could be a notice of termination of a lease and intention to evict. Doesn't really matter in a lot of respects what you call it, as long as the substance of the document complies with the statute. So first and foremost, we need to determine what the violation is. Do we have a situation where we have failure to pay rent? Do we have a material breach of the lease? Do we have a disturbing the peace situation? What is the violation? Secondly, once we know what that violation is, we are required to send that notice to quit or notice of intent to evict and termination of lease to the tenant. The purpose of that document is to inform the tenant there is a violation, to inform the tenant that the landlord is proceeding with the eviction, and to inform the tenant the lease is not being renewed. This, by statute, this notice is required to be personally served on the tenant. And it is recommended a third party serve the notice and return an affidavit of service. The statute actually requires that it is served by a third party. So in that situation, you could have a sheriff's office do it, or you could have a process server do it. We do not recommend that we do not recommend that landlords are the ones that are serving these notices. Just because the statute is clear that it has to be a third party, but it's also not a good situation when you have to prove to the court that you served the document and it's your word against your tenant's word. So it's very important if you have a third party that can give you an affidavit of service that says, I serve these documents on so-and-so at a such and such a time. The tenant is instructed in the notice to vacate the property and must be given 3 days notice before the landlord can proceed with eviction. If for some reason the tenant does not vacate it, then you can proceed with a summons and complaint. Now, if for some reason you are not able to locate the defendant or the tenant at the residence, that notice can be posted at the residence. And I'll explain that in a little bit when we talk about the summons complaint. So hypothetically, if you have a tenant that has failed to pay rent and you have had a notice prepared that says you're failing to pay rent, you have 3 days to vacate the premises. And that notice it has been personally delivered to the occupant of the premises, and they have not vacated within 3 days. The process does not stop there. Then you have to proceed with the second step of the eviction process, and that is the summons and complaint. And that's where the court gets involved. And the first step in that is, again, it's official court action for removal of the tenant. And you have to have a summons and complaint served on the tenant. Now, the summons informs the tenant of the time and place of the hearing, and the time specified in the summons may not be fewer than 3 days, but no more than 15 days from the date the summons is issued. So when you have your sheriff's office or your process server serving these documents, you need to make sure that they understand the service requirements and the complexities of the 3 days, but not more than 15, to ensure that you are lawfully proceeding and the tenant gets enough notice of the hearing. The complaint is another document that goes along with the summons, and that essentially outlines the reasons for the eviction. For example, it could be that you failed to pay rent, or maybe you're causing unreasonable disturbances in the premises, or maybe you have been found to have engaged in unlawful drug use on the property. It could be a wide variety of things, but regardless of what that reason is, it must be specifically identified in the complaint. Both of these documents, the summons and complaint, must be personally served on the tenant. And personal service is done again via sheriff's department or process server. And the statute specifically requires that if a tenant cannot be found, documents can be posted after service has been attempted at least twice between the hours of 6 p.m. and 10 p.m. And again, most of the sheriff's offices that handle these types of service requests are familiar with this process, but you can't post these documents until after there's been a valid attempt to serve someone personally at the residence. And again, we do recommend a sheriff's office or a process server to be completing these service documents for you. You must have an affidavit of service or an affidavit of posting signed by the sheriff's deputy or the process server. And the reason for that is the court is going to want verification and documentation that you have gone through the process of having these documents formally served pursuant to the statute. Once all of those documents are done and that process is completed, all of the service documents must be filed with the court, as well as the notice to quit, the summons and complaint, and any other documents that might be relevant. We generally also attach a copy of the lease agreement. If there are any addendums to that lease agreement, all of those get copied along with the summons and complaint when we file them with the court. Now, generally at this point, the tenant usually has not vacated the residence still, or maybe they have, regardless. The third step in that process is the hearing. And that can be a simple process. It depends on whether the tenant shows up or the tenant doesn't show up. If the tenant does not show up, it's very likely that the landlord is going to obtain a default judgment. Basically means that I win by default because the other party didn't show up. And in a lot of respects, those do happen. Those happen very frequently, that the tenant doesn't show up. And then essentially the landlord would get a judgment for the premises, having the premises immediately returned to their possession. And if it's a situation where there's undue rent, unpaid rent, then they would have a judgment against the tenant for the amount of the unpaid rent. Now, on the second example, if the tenant does show up, the landlord must present evidence supporting the eviction. Now, this can come in the form of testimony from the landlord property manager. It will come in the form of a copy of the lease agreement. If there are ledgers for past due balances showing any amounts due and owing, if there are photographs with regard to the property, if it's a situation where there's been damage or smoking or loud parties or something like that. And after that has an opportunity, after the landlord has an opportunity to present this evidence, then it's the tenant's responsibility to go. And the tenant does have an opportunity to testify at the hearing, but they are prohibited from raising any counterclaims except a set off to a demand made for damages or for the rents and profits. So when it comes to an eviction action in court, the judge is not going to sit there and talk about all of these other tangential issues. The matter from front of the court's position is, has there been a violation of the lease? And if so, how many days am I going to allow the tenant to remain in the premises before vacating? And ultimately, the judge does rule on the eviction and whether or not it's maintainable. Now, I have had situations more often than not where a tenant will show up at the proceeding, but they do not contest the eviction. And if that is the case, then generally what we do is we skip the whole process with regard to the testimony being given by the landlord, and we just proceed to how much time is the court going to allow the defendant to remain in the premises until they have to vacate. And that gets us to step 3. So if the court finds for the landlord, the court shall enter a judgment for immediate restitution of the property. If the tenant demonstrates that immediate restitution would be a substantial hardship, the court may grant the tenant up to 5 days to vacate the property. There is one exception, and that is if the eviction is for disturbing the peace, immediate possession is granted. So if the tenant came into the property or the court proceeding and said, I have a sick child, they're in the hospital, I would like 5 days, very likely that the court would grant that. Sometimes the landlords are very good about saying, we'll give you the full 5 days. I had just had an eviction last week where it was a young woman and 3 minor children, and the landlord recognized, the hardship on that young lady and said, we'll give you the full 5 days. But if it's a situation where, someone's doing drugs in the property or, they're tearing up the property, you probably want to not push for the 5 days because there's more likely to be additional damage done to the property while that tenant remains in the unit. So it's all kind of done on a case by case basis, but bottom line is absent an agreement from the parties for additional time, the most time the court can allow a tenant to stay in the premises in the is 5 days. Of course, the landlord, that is only done in the event of an agreement between the parties. Ultimately, there will be a judgment for eviction that will require the defendant or the tenant to vacate within a certain time frame. And then if it is a money judgment situation where there's past due rents, the judgment will also generally provide for a monetary judgment in favor of the landlord. If for whatever reason that tenant gets that judgment against them and they do not vacate the property within that allotted time granted in the judgment, then the landlord must proceed with the 4th step of the eviction process, and that's what we call the writ of eviction. Now, as a landlord, if you get that judgment and they have 5 days to get out, and on the 6th day they do not, you are not allowed to go and physically remove them. It's a bad news. Don't do it. It will get you into a lot of trouble. What you have to do is you then have to go back to the court and you have to get a writ for eviction. And that is issued by the county clerk of court's office, and it's executed by the sheriff's department, which means that the sheriff's office takes the writ and they take that paper and they go to the tenant and they say, we are going to physically remove you from these premises. And once that happens, then and only then can you then go in and get possession of the premises lawfully. You cannot do any sort of self-help remedies in the state of North Dakota. So special considerations with regard to that, again, you cannot employ any self-help remedies or methods. You can't wake up one morning and say, they haven't paid rent, I'm going to change the locks. You can't go into their premises and remove any personal items and hold them as collateral. You can be responsible for treble damages in the event that you do any of those things. And treble damages basically means 3 times the amount of damages. So that's significant amount of liability in the event that you're engaging in that type of conduct. So you certainly do not want to be doing anything of that nature. Evictions require court's involvement, and you got to make sure that you're following those proper procedures. Otherwise, you can get in some very serious trouble. I would also recommend, as it relates to anything nowadays, document all communication with the tenant. That's text, emails, notices, whatever the case may be, because you could very well find yourself in a situation when it comes down to a court proceeding, your word against the tenant's word. And it's always better to have written communication supporting your position as to what you said to the tenant and when you said it. Another special consideration that we often deal with was, and is service animals. That's becoming a little bit more acceptable in our society today with regard to mental health and other various things of that nature. So also have to remember that service animals are not pets. That the Federal Housing Association, FHA, does not require a service animal to be trained or certified. You have to evaluate requests for a reasonable accommodation, taking into consideration whether a person has a disability. And is there a disability related to the need for the service animal? You can also factor in whether there's any direct threat or harm to others. And you're not required, nor can you request a pet deposit for a service animal. And you can certainly ask for documentation if disability is not readily apparent, which again relates back to the need for a service animal. If you have a tenant who is blind and they have a service animal, that is an apparent disability. However, if it's a situation where there might be some underlying depression issues or something like that, that's not readily apparent on the surface, and they requested a service animal, you could ask for some very basic information to support that request for a service animal. Okay, that is in a nutshell, the eviction process. It's short, it's sweet, it's simple, because that's the way the statute is written. I think the statute in North Dakota is very landlord friendly in that regard, because it just provides very particular requirements, and it only allows the tenants to remain in the premises so long after there's a judgment for eviction. But it is a very streamlined process nowadays. And hopefully none of you ever find yourself in a situation where you have to use it. But that is the eviction process in a nutshell. And so I would have any questions, be free to answer any questions anybody has.
The first one, assuming this information is for people with a current lease, not month to month. Or is it for everybody?
It's for everyone. So, you have a situation where if the tenant is a 3-year term lease and the tenant is not paying rent, well, you don't have to have your tenant stay in there for 3 years not paying rent. Or if your tenant is smoking in the unit, that would apply to whether that's a 3-year term, a 1-year term, or a month to month. The eviction statute applies to any lease in that situation.
Next one, can we get a copy of the PowerPoint slides?
That's totally fine. I have no objection to that, Kylie. I can certainly give that to you, and you can certainly share that if you wish.
Okay. Does anybody else have any questions? Is there any situation where lock changes are acceptable?
It's hard to say without some kind of really weird situation, but the general rule is, unless you have a situation where you can confirm that the tenant is actually vacated and you have some very good evidence to support that the tenant has officially vacated, then you potentially could. But if it is a situation where you're not sure, or the tenant is still in the unit, then no, you cannot. That would be considered a self-help remedy. And then you have to, proceed with the court if that tenant is still in the unit. Now, if that tenant hasn't been in the premises for 4 weeks, and you've heard statements that the tenant had made about, they were leaving and not returning, and they had made those statements to another individual in the complex, and you were able to verify some of those statements, could you go in and do a notice based on posting a notice and go in and see? And if the unit is been vacated and there's very little items in there, I think based on that, you could probably say that tenant has been abandon the unit. But in that situation, I would always recommend that you follow that up with some sort of written documentation to the tenant at the last known address or other email address, or a text that says, we inspected the unit and the unit appears to be empty. Please confirm that you are intending to vacate the unit. Because all of that goes back and documents your communications and your correspondence with the tenant in the event the tenant ever came back and said, I never intended to vacate the unit.
A question that kind of goes along with that. Can a landlord change the locks if you move out before the 30 days and you still have stuff in the apartment?
The 30 days, I presume we're talking about a situation where this is on a month to month, but normally if the landlord, if, for example, the court gives 5 days, you have 5 days. The court is going to give the tenant that 5 days. If you've got a situation where you've agreed that the tenant has 30 days to vacate the unit and you want to go in and start changing the locks, my recommendation is that you don't do that. You wait until that full time has expired, because that's what's been agreed to. And or because the whole point of changing the locks is to keep the tenant out. So if the tenant has the lawful right to be there for a certain time frame, the last thing you want to be doing is limiting that right, which then can lead back to those self-help remedies, which you do not want to be getting in trouble for.
Can a landlord refuse to use ND rent help and continue in the eviction process?
I'm not 100% sure on that. I don't think that there is a legal requirement for a landlord to do that. I think that's a decision by the landlord to determine whether you want to try to keep this tenant in the premises, whether you can get additional funds out of the tenant. And maybe there's other reasons why you would want to evict the tenant. Maybe this isn't just a rental situation, but maybe you also have circumstances with the tenant's conduct in the unit. So I think that has to be a case-by-case situation analysis, and I think it's going to be dependent upon your tenant. And maybe this is a problem tenant and you don't want to do that. Maybe you have a tenant that this really is based on a hardship financially and you want to try to do everything you can to help that tenant. I personally think that if you found yourself as a landlord in front of a judge and the tenant said, "Judge, I tried to get rent help and they refused it," it is not going to look good for a landlord. But that doesn't mean that you have to do it. I'm not aware of any legal reason why a landlord is required, but I would tread lightly on that one because the program is there to help individuals with their rent assistance. And oftentimes in those situations, what I have seen is they have used the program or they have failed to adhere to the program's requirements, or they kind of phase out of the program. So oftentimes some of those tenants will not afford, or they won't, for whatever reason, sometimes they just don't do what they're supposed to do as far as that program is concerned. And eventually that program may not be a viable option for them in the future. But certainly would encourage anyone to be open to the idea of using that, because that's a way for landlords to get paid for having these individuals in their units without going through the eviction process, and also trying to help struggling individuals pay their rent.
Okay. So if a person gets 3 days to evacuate the property and it's just a note on the door, that is not a true notice.
So you have to give the notice of intent, and that has to be personally served. If you cannot locate the tenant personally by physically handing them the paper, then the notice of intent to evict can also be posted in the same manner as the summons and complaint. But as I said, I do not recommend that landlords are the ones posting these notices. The statute is clear that it has to be a third party, and you should be having a process server or sheriff's office going over there and slapping that thing on the door after an attempt is made to personally serve that person. Because if that notice is ever questioned about how it was served, when it was served, or who it was served by, you don't want to be getting in a situation where it's the tenant's word against the landlord's word. You want to have a mutual independent third party process server be able to come to the court and said, yeah, I served it. I served it on such and such a day after I made these attempts. It just takes the ambiguity out of it. Yes, you're going to pay to have it served, but at least you're going to know that you had it done correctly, and it's less likely to be challenged by a judge.
All right. This next one's kind of a 2, if not 3-part question. Are there regulations about how to document lease infractions that might lead to eviction? For example, another tenant is affected by someone smoking in their unit despite a no smoking rule. The affected tenant reports it, and the management says they can't do anything because it's based on tenant report. What are the requirements of the landlord? How does the landlord document a situation like this? Can a landlord give a lease infraction without seeing the actual proof?
Well, I would say that there's no set rules or regulations as to how these infractions or these issues get investigated. I would say that in that situation, smoking is a little bit of an obvious one because, if somebody's smoking in the unit, you're likely going to know because of the smell. We had a situation in Williston a couple of years ago where we had an older lady that was just smoking like a chimney and caused other tenants to vacate the premises because it was that bad. And so, in that situation, if I were advising a landlord, I would say, okay, you have this complaint. Visit with the tenant, let them know that this has been going on or this has been brought to your attention. You could very well do a inspection of the unit based on a notice to the tenant. And if you go into that unit on lawful notice and it smells like smoke in there, that's a good reason to believe that the person has been smoking. If there's ashtrays all over the place, if there's cigarette butts, that's evidence to support that they are violating the terms of the lease. And then as far as the documentation back to the tenant, certainly needs to be in a written format. I think everybody's agencies have a little bit different, or every landlord has a little bit different form, but the substance of it is, on such and such a date, I inspected the unit. Here's what I discovered. This is based on a tenant report on such and such a day. We have reason to believe that you're in violation. You have how many days to correct this conduct. If it happens again, we will likely, proceed to eviction. If you have any evidence to support why these allegations may or may not be true, please provide that to our office and we can discuss that further. But it's more of a notice to the tenant, put them on notice that you're aware or you have reason to believe that they're in violation of the lease. Give them time to correct the conduct depending on what it is. And if that's the case, then you would proceed with eviction. It's more often not in a judge's perspective I think, to say, going in there and saying, Your Honor, we gave the tenant every opportunity to make this right before we got here. We talked to them about this. It's up to the tenant where they're going to change their conduct. And if they're not, well, then we have no choice but to be here. And this is an eviction process at that point.
Are there agencies that assist tenants with answering the unlawful detainer?
I think I've never had an agency step in on behalf of a tenant. Could you get some help maybe through legal aid of North Dakota or legal services of North Dakota? A tenant potentially could, I suppose. But that would be the only agency that I think would step in. Once you got to the legal side of things, a tenant always has the right to hire an attorney and show up to these things. they could always have some sort of assistance through companies like Rent Bridge or something like that, or programs. But as far as agencies that provide legal assistance for that, the only thing I could think of would be Legal Services of North Dakota, which is basically a program across the state of North Dakota where lawyers are hired by the state, and they represent individuals with a lower income and things of that nature. But I think you got to qualify for some of that stuff, and I'm not a expert on legal aid in North Dakota, but I think that would be probably the best paid place to start if a tenant had a question on it.
Okay. Let's see here. If a tenant leaves a property and has left behind personal items of less than $2,800 worth of value, how long does the landlord have to wait to remove if the tenant had been evicted?
The statute requires you have to hold that property for 28 days. So you keep it. I generally would recommend that if there is property left in the unit, if it's under a certain value, if it's over a certain value, regardless, whether there's property in the unit, and if it's a t-shirt, that's it, fine, whatever. But if it's a couple pieces of furniture or this, that, or the other, and you have to hold it for that time frame, I certainly would recommend that you send a notice to the tenant, to the last known address, or an email address, or a text or something that says, we've inspected the unit and you have left some particular items of property in the unit. Be advised that you have 28 days to retrieve this. If you do not retrieve the property within that set amount of time frame, it will be disposed of pursuant to state law or something to that effect. It's just another piece of documentation that you have as a landlord to show that you've done your due diligence, you've informed the tenant. And whether the tenant decides to do anything with it or not, that's on the tenant, but the landlord has given that notification.
Okay. If you communicate via USPS, do you recommend a certified letter with return signature?
Yeah, I mean, it depends on what you're doing. I suppose if you're serving a personal service can be done, certified mail return receipt requested. You certainly could do that. It's up to you. I think it depends on the nature of the service. But yeah, I mean, it's just another way to document what you sent. If it's a problem tenant, then probably you just kind of have to judge that on a case-by-case basis.
If they move out within the 3 days, do you recommend continuing with court?
If it's a situation where it's a failure to pay rent situation, then I generally do recommend that you proceed. And most of the time, if we've gotten to that point, I just do recommend finalizing it, because there's always a chance that tenant could come back to the property, especially if it's a failure to pay rent situation and you want to get a judgment for that amount of rent. Then we do need to proceed with the court, and we do need to have the court give us a judgment for the amount of the rent. Otherwise, there's going to be no official judgment for that. So by that time, like I said, we've gotten so far into the process. And if they're already vacated the unit, it's very likely they're not going to show up at the hearing. So your hearing was likely going to end in default, which is probably going to take 5 minutes. At that point, I would say cover your bases. You're that far into it, just finish it.
All right. If someone is living in a home with the understanding that they are to care for the land and home, but not doing so with no rent collected, how do you go about evicting them if they are not holding up their end of the agreement?
That's that's a little bit more complicated than simply this type of eviction, because that could be a highly complicated contractual issue between the parties that might not be suitable for this type of proceeding. You could very well find yourself litigating that type of case over and above a simple eviction action, because tenants in that situation could respond in a court action and say, well, I didn't pay rent, but here's all the other reasons why I didn't pay rent. That might be more complicated than just a simple eviction. You could certainly try it, but if the facts are such that it's not as simple as, that you could likely find yourself in a more of a litigated type of situation in that regard. So answer would be, is that's going to be really fact dependent on what's the understanding between the parties as far as the requirement for the non-payment of rent and what the services are to be rendered and so forth. So that one's, again, a little bit more fact dependent than just a simple, you have a lease in place and you're not paying rent.
Okay. We have had a landlord that has refused to let the tenant back in to get their items in the 28 days. They made it difficult by saying between 8 and 10 on the 28th day. What is the obligation of the landlord?
Well, I think the landlord has to give the tenant, or should give the tenants, access to the property or make arrangements for the tenant to get the property. There is no set requirement that I'm aware of by statute that requires the timeframes or anything like that. I think that at the end of the day, yes, we have problem tenants, but the most important thing that, you want to get their stuff out. You don't want to hold on to that. Just work with them to get it back to them. Be reasonable. If it ever ended up in front of on a court, or the tenant said that, or made a claim in small claims court or something for conversion, basically saying that the landlord is unlawfully possessing my property and will not give it back to me, I wouldn't want to be standing there in front of a judge and be defending a client that said, well, I gave him 1 hour on the 28th day, and if he couldn't show up, well, that was too bad. It's not a good light to be in. So a lot of that is just using common sense, especially if these items are of little value. Just work with the tenant to get it back. If you need law enforcement to be there to make it happen, arrange it. But you don't want to be that person that is perceived to be that way, because if you do end up back in court for whatever reason, a judge is not going to look kindly on that.
All right. Any more questions? If a tenant gets into a physical fight with another tenant, can you evict just one of the tenants, or must the landlord evict both tenants? Police were called.
I would say that would be fact dependent. If it was a situation where you've got two tenants that are, for example, drunk as you can imagine, and they're outside their units screaming and yelling at one another, and they get into a mutual physical altercation, I'd say you're out, both of you. If it's a situation where a drunk tenant shows up and starts banging on another person's door who's not doing anything wrong, and then a fight ensues between the two of them, and one is claiming, self-defense or something of that nature, certainly against the one who's the aggressor, maybe not against the one who's defending himself. So it really kind of depends on the facts of the situation and how you want to treat those as it relates to each individual's conduct as part of the action.
Can a tenant withhold rent due to the apartment becoming uninhabitable due to water leaks?
I would say likely not, that you still have to pay rent, but understand as the tenant, or excuse me, as a landlord, if you've got a situation where you have got water leaks, you have a responsibility to make sure that you are providing a habitable dwelling. And so, that would be a situation where you need to get in, you need to fix it and figure out exactly what's going on. But generally, no, you're not allowed to do that. Could there be a reason for it? I guess it would be a situation maybe where the tenant and the landlord mutually agree that while that's going on, no rent would be paid, but usually those are done on a situation where the tenants and the landlord agree on those types of things. But if there is a major issue like that, then obviously the landlord needs to get in and get it fixed as soon as possible.
Would you still recommend sending a letter if no email or text option is available regarding abandonment or item removal to the last known address, even if that address is the unit in question? Often I don't have knowledge of the tenant's location beyond their unit, especially after non-payment of rent resulted in an abandonment inspection.
Yep, I know it sounds kind of crazy as to why you would do it, but it doesn't hurt. It really, really doesn't hurt. You might find yourself where, yeah, he's not going to be there because he's not in the unit. But it's another layer of documentation. When you're filling out applications, it isn't a bad idea to ask for an email address or an alternate address of some sort, where, if you're not here, where else could you receive mail? So those are just additional ways to communicate with your clients in the event a physical address is not a viable option.
What type of renter's insurance and amount is recommended?
I have no idea. That would be a great question for an insurance agent. I think renter's insurance is a great thing, depending on the value of the items that you have in your units. I mean, if you've got a coin collection that you keep in your apartment building that's worth $50,000, then a rental insurance policy for 10 is probably not going to be adequate. So that would be a question I would defer to your insurance agents. They're going to be able to answer that better than I would.
Can you record audio conversations with tenants without their consent? And are those conversations admissible evidence in court?
In North Dakota, you can record someone as it's a one-party state, which means that you can record as long as one party is aware of the conversation. I do not recommend that. If you're going to record them, make sure they're understanding what's being discussed and that they are being recorded. It's just not necessarily a way to do good business. You sure want to have documentation with your tenants, but nothing wrong with saying, hey, this is being recorded. Just want to make sure that we have documentation down the road. But I generally don't advise stuff like that. I think it's not perceived very well that you're trying to do something underhanded by recording somebody. They're going to say what they're going to say, regardless of whether it's being recorded or not in most contexts. So if you're going to do it, be upfront about it and tell them.
Can a client hold off on rent payments if a landlord refuses to fix things? For example, AC, not that this matters now, fridge, oven, mold, and bed bugs. Landlord refuses to fix it because they aren't getting paid. I think the landlord just doesn't want to fix these things.
Well, the landlord is, like I said, required to provide a habitable dwelling. I've had some recently where the state health department, tenants have contacted the state health department, not in my capacity individually, but through certain city ordinances. So, to all the landlords out there that might find that you can do that or want to do that, I would certainly not recommend that you do that. And you could find yourself facing violations from the state health department. So do not be doing that. Also, I don't think that it's appropriate to withhold rent, but certainly I can understand a tenant's position in that, but that's a mutual agreement or a two-way street there. So tenants often then, at that point, you might find yourself in a situation where you need to find a different landlord, one who's going to actually maintain a habitable dwelling.
All right. Well, that seems to be the last of the questions. Thank you again, Christina, for presenting to our group. Always great information and refresh your course. So thanks again. Thank you, everybody, for attending today's session. Again, please take a couple minutes to fill out that survey. Marilyn just sent it out, so it should be in your inbox. So just take a couple minutes and get that filled out. Again, if you need a certificate of participation, please email Marilyn and she will also get that sent out to you. So thanks again for attending today's session. Next week, we have homelessness in schools as our topic. So hope you can join us then. Thank you again and have a great day.
Thanks, Christina.
Yep, you're welcome.